Mr. Speaker, just a few weeks ago, this chamber was filled with members of the House of Representatives, and all of us stood up, raised our right hand, and we took an oath to support and defend the Constitution of the United States. Same oath the President takes, others take, the military. And we do that for a lot of reasons, but the main reason is, in this country, the Constitution is paramount to all other law. And I agree with that philosophy. The Constitution, I think, is a marvelously written document, as well as the Declaration of Independence, that justified the reason for us to start our own country. Attached to the Constitution are what is commonly referred to as the Bill of Rights. Rights to the people and prohibitions against government intruding on those rights. And they call the Bill of Rights. There were originally 12, 10 of them passed, and that's why we have 10 instead of 12 under the Bill of Rights. So I'd like to start and talk about only one of those rights. Since there's only 30 minutes, I'm going to talk only about one of those. And it's the Fourth Amendment. And let's go through it together, Mr. Speaker. Fourth Amendment to the U.S. Constitution. The right of the people, that's us, to be secure in their persons, in their houses, and papers, and effects against unreasonable searches and seizures shall not be violated. That sounds pretty absolute to me. And no warrant shall issue but upon probable cause, supported by an oath or affirmation, comma, and particularly describing the place to be searched and the persons or things to be seized. Now, you don't have to be a legal scholar or a lawyer to understand what this is talking about. It's the right of privacy. That government, to go into our homes and our effects and our things and our stuff, generally cannot do that, except under circumstances which require that they go get a warrant. Now, I used to be a judge. Judge Green, who was just in here a while ago, he used to be a judge. What that means is the police, generally, go to the judge and say, Judge, in a written document, with the affidavit that they swear to, the affidavit states, I believe, that there is, let's say, drugs, cocaine specifically, in Bobby Oglethorpe's home. Bobby Oglethorpe's notorious Texas outlaw, so I'm going to use him as the one. And it describes what they're looking for. They say where it is, and they give the address of where Bobby Oglethorpe lives in Houston. And then I read it to see if it states probable cause. What does that mean? Well, there's a lot of definitions to it. But basically, it proves, the statement proves with the affidavit of the peace officer that there's probable cause to believe that that item is where the police officer says it is. And drugs, so that would be illegal. Then the judge signs the warrant. What that does is orders the police officer to go to that specific location in a certain time frame. Can't do it for like forever. You don't have 6 months to go look for it. Usually 3 days. You go over there and you search that address looking for that specific stuff, cocaine, drugs, that are in the possession of Bobby Oglethorpe. Then the police officer normally would leave a document with the person at the house as to what they seized. Officer comes back to judge and says, Judge, I executed the warrant you gave me to Bobby Oglethorpe's house, and I've brought you back the return on the warrant, what I seized, because I was ordered to go get it, and that files the return in the court with the clerk. That varies from state to state, but basically the concept is before government goes into your house or other things, an independent person, a judge, has got to separate the law, the police, from the citizen and make an independent decision as to whether or not what they're looking for is where it is or they have an established probable cause. Now, that's a generalization of the whole concept of warrant. Why do we even have these things? It goes back to our history, our American history. Everything seems to be based on history, and it's good that we reflect on it. Back in 1761, America is not a country, it's a colony, made up of 13 colonies. And at that particular time, this is not a new thing about warrants. This is not a new thing. British subjects who lived in England specifically, they had the right to have what is called a specific warrant issued against them before they would have to give up the item, as opposed to what I will show you is a general warrant. Generally speaking, before a magistrate in England would allow some British subject home to be searched, the peace officer would have to go to a magistrate and show some specificity as to where the document or the item was with some type of probable cause. But coming to the colonies, that was not true. English magistrates that ruled over the colonies did not give colonists the same protection as other British subjects back in England. So what would occur is this. Those colonists, it has been said, were eating rum. Rum that had been brought into the United States, the colonies, and other things, and hadn't paid the tax on the rum. And so the British would go to a magistrate and say, give us a general warrant to go search, let's say, Bobby Oglethorpe's great-great-great-grandfather. Search his warehouse to find any items that may have not been stamped with the appropriate tax. Colonists didn't like that. That's a general warrant. You got a piece of paper from a magistrate saying, go over there and look around, see if you can find something that is illegally in the possession of the colonists without the act or without the Stamp Act on there. These were called writs of assistance. They were called general warrants. Pretty much the same thing. I won't go into the difference of those two individuals. So colonists, being the type of folks they were, Massachusetts, they took them to court. They took the British Crown to court. Their lawyer was James Otis, and he protested in a courtroom saying, your warrant is not specific enough. It's too general. British judge, magistrate, ruled against the colonists. And there were several businessmen that were being sued in this case. Now, that may not seem like a big deal, but John Adams, who later became President of the United States, observed all of this. And he said that act was the spark in which originated the American Revolution. What is that? The act of government invading the privacy of the colonists. And he said that sparked the revolution, what we now call the Fourth Amendment, because the colonists weren't protected from unreasonable searches and seizures. They weren't protected from specific warrants saying specifically what they were looking for in a specific place based on probable cause. Local magistrate would just write out a document saying, go over there and look at this warehouse, see if you find any, in this case, rum that doesn't have the stamp, doesn't have a tax on there. So our history shows that this is an important concept. Now, what does it require? It requires a specific warrant as opposed to a general warrant. It requires that it be specific as to what you are looking for. It's got to be based upon probable cause. It just doesn't give the police the authority to go into someone's home and look around and see if you find some contraband. You got to have it based upon probable cause, sworn to, and it's limited in scope as required under the Fourth Amendment, which we will read again if we have enough time.